Hello everyone. It's just on 11, so let's give people a couple of moments to join. I think they're still joining, and then we'll get started. Hope it's a nice day where you are. The sun is still shining here in downtown Milton Keynes. Just checking, there's still people joining, so we'll just wait a little moment if you don't mind. Okay, might get going. So, good morning, everyone, and welcome to our webinar today. For those of you who haven't attended one of these before, I'm Sarah Gray, Director of HR at Sintra. And let's start with a bit of product disclosure. This is perhaps not the most exciting topic in HR, but it is a very necessary one. Today, I'll be taking you through the new trade union provisions in the Employment Rights Act 2025, and importantly, what they mean in practice for anyone working in HR or in a leadership role. Important to note, this is not only relevant to heavily unionised organisations, and I can't stress that enough. Many of you will be wondering if you really need to be bothered by this, especially if you've never had any union presence in your workplace. But even if that is the case, believe me, times they are a-changing. There's new access rights and a lower initial barrier to union recognition, and this means employers that have never dealt with a union do need to have some basic response plan. As always, we'll send you a link to the recording and a copy of the slide deck following the webinar, and I've also compiled an information sheet which we'll be sending out to you as well, and hopefully that will help. My aim is to provide you practical information on what has already changed, what to expect next, and what to put in place by the 30th of October. But to start off, a little something that I saw the other day and I couldn't resist. Yep, I'm not sure which is more daunting, actually, a Darth Vader dad or a union rep. I've dealt with both in my time, but there you go, a little bit of frivolity to start the day. So let's start by looking at why these trade union changes matter beyond traditional unionised sectors. The direction of travel is clear. Worker voice and trade union activity are being made easier. Unions will have more ways to communicate with workers, and importantly, unions will get access to workplaces for the purposes of not just talking to people about going on strike, which is current law anyway, but wait for it, for the purpose of recruiting union members. So unions are going to have the right to go into almost all workplaces, well, any with more than 21 workers, and that's not employees, workers, to recruit members. It's my opinion that the Labor government intended this to help increase trade union membership, not just because unions provide significant financial and institutional support to the Labor government, but also because, as we've seen throughout history, as collective rights go up, individual rights get used less, and vice versa. So as the collective rights and rights of unions go down, individual claims generally escalate. By increasing the rights of unions and union representation, it means that there is likely to be a reduction in the number of individual claims in the workplace. And this, of course, can contribute to bringing down tribunal waiting lists, which is something the government is very, very keen to do, to relieve the backlog on employment tribunals, which we know has been growing by the day. As part of these reforms, unions will have fewer procedural barriers in gaining recognition and taking industrial action. And there will also be stronger support for workplace representatives. And for HR, this changes the risk profile. A poorly handled request, especially something that's delayed, dismissive, or overly anti-union, could quickly become a legal and employee relations problem. The good news is that preparation for these changes is actually quite modest. You need to identify an owner for handling these processes in your organisation, train managers to respond and ensure they know the importance of escalating to your named owner, build a response procedure or a process, and importantly, ensure that you update your onboarding when the guidance is released later this year. Move to my next slide. There are 4 key dates. At Royal Assent on the 18th of December last year, the Strikes Minimum Services Levels Act, the 2023, was repealed. On the 18th of February this year, most Trade Union Act 2016 restrictions were repealed and industrial action rules were simplified. So that happened on the 18th of Feb. On the 6th of April, the first recognition changes took effect. Electronic and workplace balloting, specified statutory union ballots, starts on the 25th of August. The main HR implementation date, however, that you need to be very aware of and plan for is the 30th of October. And this is around information that needs to be provided, access rules, the recognition process, and also representative and detriment protections. But important to note, of course, that those future implementations are still subject to parliamentary process, and we shouldn't take it as absolute gospel just yet, although I have to say I'll be very, very surprised if there is any substantial change. Let's now look at the changes to industrial action that are already in force. And by industrial action, we mean actions such as a strike or employees refusing to carry out certain duties. Before a union can call industrial action, it must usually hold a ballot of the members who would be asked to take part. And at least 50% of those entitled to vote must still take part in the ballot. The union must then secure a majority of the votes cast. Now, previously, ballots involving certain public services such as health, education, and transport had to meet an additional test. At least 40% of everyone entitled to vote had to vote in favour of the action. Now, that extra requirement was removed for ballots opening on or after the 18th of February this year. There have also been some other important changes. So unions now have to provide less detailed information in ballot papers and formal notices. And an employer only needs to receive 10 calendar days notice before an industrial action begins. Now, previously, the normal notice period was 14 calendar days. Now, bear in mind the calendar days include weekends and bank holidays. So in practice, depending on the timing of the notice, this could give an employer less than 10 days working days to prepare. And of course, this is the minimum. And a union could give an employer more notice, but not sure that's likely to happen in practice. And a successful ballot now gives the union authority or a mandate to organise industrial action for up to 12 months rather than the previous 6 months. Now, that doesn't necessarily mean that industrial action will continue for 12 months. It means that the union may call action potentially on more than one occasion during that 12-month period without having to hold another ballot. Employees taking part in protected industrial action also now have stronger protection against dismissal. So previously, the main automatic protection generally covered the first 12 weeks of action. That time limit has now been removed. From the 30th of October, further protection is expected. So we think it will be employers will be prohibited from subjecting workers to a disadvantage or detriment where the purpose is to punish them for, stop them from, or discourage them from taking protected industrial action. Let's give you an example of detriment. That might be withholding an opportunity or treating someone less favourably because they took part in industrial action. So potentially not giving someone a promotion, or it could be even something like denying a flexible working request without a proper valid reason. However, employers will still be able to withhold pay for the time that a worker is taking industrial action. So what should you do in practice? I would suggest reviewing your industrial action contingency plan. You probably don't have one, but now's a good time to think about one, rather than waiting until a notice of action is actually received. So think about things like what essential services or activities would need to continue if there was industrial action, who would lead and coordinate your organisation's response, and what lawful staffing or operational alternatives would be available to you. Things like how you would communicate with your employees, with your customers and other stakeholders if your service was going to be disrupted, and how you would manage repeated periods of action, potentially over several months. The reality is that employers may now have less time to prepare and may need to manage more than one period of industrial action under the same ballot, as I said. The aim is not to assume that industrial action will happen, but to make sure that your organisation could respond calmly, lawfully, and effectively if it did. For industrial action ballots specifically, unions will also be able to arrange voting at the workplace. So different methods may be combined. A union could offer electronic, postal, and workplace voting within the same ballot. Why does this matter, you ask? Well, making voting quicker and more convenient may encourage more union members to take part, and this could make it much easier for a union to achieve that minimum 50% turnout needed for a valid industrial action ballot. It does not change how an individual must vote or guarantee that a ballot will support industrial action. It simply makes the voting process more accessible. So there is one important distinction to be aware of. A ballot to decide whether an employer should formally recognise or stop recognising a trade union is organised through the Central Arbitration Committee, or CAC. Electronic and workplace voting will not be introduced for those recognition and de-recognition ballots until 2027, so a little bit of a reprieve on that one. From the 25th of August, the immediate change for employers is mainly that industrial action ballots may become easier for union members to access and complete. So what is recognition? Union recognition is when an employer formally accepts a trade union's right to negotiate on behalf of a defined group of workers, and that's known as a bargaining unit, about matters such as pay or working hours or holidays. It is not triggered simply because one or a number of individual workers are members of a union. So let's look at an example of what that actually means in practice. Say an organisation has 200 employees, including 80 production workers. Some of those production workers are trade union members. However, it's important to distinguish union membership from union recognition. Any employee is free to join a union, but their individual membership does not automatically give that union the right to negotiate pay and terms on behalf of the wider workforce. For that to happen, the union must be formally recognised for a defined bargaining unit. Recognition can be agreed voluntarily with the employer or obtained through the statutory CAC process. So in the scenario I mentioned, the union would need to apply to be formally recognised to represent the 80 production workers, and that group would be the proposed bargaining unit. They could then negotiate collectively with the employer on behalf of that 80 production workers group about matters, as I said, including pay, working hours, and holidays. Employees outside of that bargaining unit would not normally be covered by those negotiations. So just on this, even without recognition, an employee may still ask an appropriately certified union representative, obviously, to accompany them at a disciplinary or grievance hearing, as you probably know. A bargaining unit is defined by objective characteristics. So, for example, it could be by job role, it could be by department, it could be by grade, or it could be by workplace location, or a combination thereof. Once it is agreed between the employer and the union, or if they can't agree, determined by the CAC, it covers everyone who falls within that definition. And that also means workers or employees who are non-members of the union. And I think that's something some people have trouble grappling with sometimes. And it means that any new employee joining the business who falls within that definition of that bargaining unit will automatically become part of the bargaining unit as well, regardless of whether they become a member of the union. So if the bargaining unit is defined as all production operatives at the Newcastle site, as an example, an administrator working at that site could join the union, but would not become part of that bargaining unit. And conversely, a production operative would be covered by the collective bargaining, even if they weren't a member of the union. I hope that makes it clear for everyone. And as the slide states here, the process for recognition is this. A union normally first asks for voluntary recognition, and if that is not agreed, it can apply to, as I said, the Central Arbitration Committee. The CAC will consider admissibility and the proposed bargaining unit and support, and then the matter may proceed by agreement or, if not, by ballot. A recognition request received by anyone in the business must be escalated immediately to your named or nominated person who will then deal with this issue. So if it goes to a manager, make sure they're aware of what to do. Do not allow managers to refuse a request or potentially begin canvassing views. That is not their role. As soon as a request is given, it needs to go to whoever you've nominated as the owner of that process. From the 6th of April, a union no longer has to persuade the CAC at application stage that a majority of the bargaining unit is likely to support recognition. So in other words, the rules have changed to make it easier for a union to gain formal recognition. If a recognition ballot is held, the union now only needs to win a simple majority of the votes actually cast. So this is important to understand. Let's take the example where you've got 60 employees vote. In this case, the majority, 31, must vote in favour, and it's regardless of how many workers defined as being in the bargaining unit. So if you had 100 or 200 workers in the bargaining unit, but only 30 people actually voted, then the union only needs a total of 16 votes. So that's quite incredible. Previously, The union also had to secure support from at least 40% of everyone in the bargaining unit, including those who did not vote. So that additional requirement has now been removed, and as I said, that's a massive shift. One more to be aware of. Before a union can make a statutory recognition application, at least 10% of the workers in the proposed bargaining unit must currently be union members. So, for example, if the proposed bargaining unit contained 100 workers, the union would need at least 10 members within that group to be union members. Although the Act allows the government to reduce this threshold in future, and there's been talk of it going as low as 2%, but it hasn't been done yet, so let's not worry about it just at the moment. There's enough things to be concerned about, right? Further changes are expected from the 30th of October 2026, and these include fixing or freezing the bargaining unit at an early stage. And I guess that's so the size cannot be deliberately changed or manipulated after the union applies for recognition. Also allowing the unions to communicate with the affected workers earlier in the recognition process. And the other change is strengthening the rules against either side using threats, pressure, bribes, or other improper tactics to influence the outcome. From the 30th of October, an independent union may formally request physical, digital, or combined access to a workplace to engage with workers. The rules are that when this happens, the employer must respond within 15 working days of the request being sent. So that's important to note. This means from the date that it was sent, not from the date that you open it or read it. So more precisely, the response period ends on the 15th working day after the day on which the request is given. And the current government guidance describes this as 15 working days from the request being sent. So let's go through an example of those timings. The union sends the request on Monday, the 2nd of November. The countdown for those 15 days begins on Tuesday, the 3rd of November. So the employer's response is due by the end of the 15th working day, subject to weekends and any relevant public holidays. From your own procedural perspective, I would suggest you recall both the date it was sent and the date it was received. After this, the parties have a 25 working day negotiation period. So if there is no agreement at the end of those 25 days, either party can then apply to the CAC. Now, again, we have to keep a watchful eye out for any changes to this as this part is still in draft. It will then be up to the CAC to determine whether access should occur and on what terms. And remember, the CAC can only impose an access agreement where the employer has more than 21 workers across all of its locations. That's not by site. If you've got 21 workers across all locations, it will apply to you. A key message here is silence is not a strategy here. If you get an access request, acknowledge it quickly and abide by the deadlines that have been imposed. Now let's look at what reasonable access could look like. Physical access. This might involve a meeting room during a break or before or after a shift, of course, subject to site security and safety arrangements that you might need to put in place. If you're in an office environment, this is probably likely to be quite straightforward. Then you've got digital access. Now, this could include a facilitated online Teams meeting or an employer cascaded email even. The access agreement is negotiated and will be agreed between the trade union and you as the employer. And the process looks a little bit like this. The union will begin by explaining what access it wants, or it should. HR or another nominated individual, if you don't have an HR department, should then coordinate the employer's response and negotiate practical arrangements with the union. And once agreed, the terms should be recorded in writing and confirmed by both sides. The agreement should set out who could attend or who may attend, which workers they may contact, where and when access will happen, how often it may occur, and any reasonable safety, security, confidentiality, or digital access arrangements that have to be put in place. So, what is this new duty to inform workers? This is the next thing on our agenda. It's probably the one that is being most spoken about, and one that you may already have heard about. From the 30th of October, employers must provide workers with a written statement informing them of their right to join a trade union. The statement must be provided at the start of work alongside the written statement of particulars that you already are obliged to provide. And there is also likely to be a requirement to reissue this at other prescribed times. It could be annually or at different times the government may decide. The exact content, the method, the timing and coverage will be set by secondary legislation, and we're expecting this guidance to be issued in September. We'll of course let you know about it when it happens. My suggestion is to prepare the workflow now, but wait for the prescribed detail before finalising anything. It would also be good to identify every effective template and system that you might need to update. So things like your offer or contract pack, your written particulars, you might have an onboarding checklist that needs to be updated to include this. And also, if you've got an HR information system, what's the onboarding workflow? Are there any changes that you need to make to that? So start thinking about what might need to be changed, and then as soon as that guidance is released, you'll be able to do that. And also to update your document library with any information that you provide at this point, and review any audit trails so that you're fully prepared as well. We're now going to look at the additional practical support that these changes provide to unions. From the 30th of October, employers will need to give workplace union representatives reasonable support to carry out their roles. And of course, we all love that term, reasonable. The revised ACAS code will guide reasonableness. And this may include paid time away from their normal job and access to suitable facilities to carry out their duties as a union rep. For example, a union rep might need paid time to attend a meeting with management, paid time and access to speak to the employees they represent, or they might need to undertake relevant training. Union equality representatives will also have a specific right to reasonable paid time off for activities relating to equality in the workplace. Employers may need to provide practical facilities such as I said, a private meeting room, or as I said, access to emails or an online meeting platform, and potentially somewhere secure to keep relevant documents. That could be electronic or in hard copy. Be aware this does not mean that every request must automatically be approved exactly as the union submits. But the amount of paid time and the facilities provided must be reasonable, taking account of both the representative's duties and the organisation's operational needs. So HR really should put a simple process in place so that representatives know how to request time off or what they need to do to book facilities, and managers need to know who can approve those requests, and the organisation should have a process to keep a record of what's been requested, what's been denied, why, and what's been agreed to. As I said before, the revised ACAS code will help employers decide what is reasonable. Your communication with managers about this is going to be important. Managers may have strongly held personal views about unions, but within their role, they need to remain professional and avoid interference or showing any bias. They should not question employees about union membership, threaten any consequences, or promise any improvements or benefits that are conditional upon an employee rejecting a union. They must also be careful not to treat anyone adversely for their union activity. A safe script for the business to follow in relation to union membership is something along the lines of: employees are free to decide whether to engage with or join a trade union, and to direct formal requests or questions to HR so that, that they can follow the correct process. That's the safe way. Important to note, neutrality does not mean management cannot communicate facts or explained operational needs. So it just means that you need to do so without pressure, inducement, threat, or of course, victimisation. So it doesn't mean to say that you can't have a different view or a different solution to what is being suggested. It just means that you need to be fair and considered in how you deal with it. What should your first response procedure look like when you receive an access request? First, channel the request to the named owner or the HR lead or another appointed senior manager. So make sure everybody is aware that if they get an access request, where it needs to go to. Don't let it just sit and fester, because you've got a time limit here. Second, the person who's named would normally verify the union. Who are they? And clarify the workplaces that are being asked to be accessed, the workers, the purpose of the access request, and the proposed access they are after. Third, acknowledge receipt of their request, but at that point, don't give any indication of whether you are likely to refuse or accept the request. Basically, just that you acknowledge receipt of it, and then you will need to have an opportunity to undertake an assessment. It's a bit like a flexible working request, right? You need to show that you're giving it due consideration. So you don't go yay or nay straight off. Go, thank you for that. We've got it. We'll now look into it. And then you go back to tell them. Diarise the 15 and 25 working day deadlines. You don't want to miss those and give the union any opportunity to use that against you, because they will. At this stage, if the employer misses the 15 working day response, the union can apply to the CAC, and the employer then loses their opportunity to manage the request through an early negotiated response. So it almost gets taken out of your hands. So it's important not to miss that deadline. And then if no agreement is reached within the 25 working day negotiation period, the union or the employer can apply to the CAC to decide whether the union should be given access and on what terms that access must be given. So this means that the employer may end up with arrangements that might not suit them. So if you can reach agreement, that's always the best way, of course. So always attempt that in the first instance. It might be worth also mentioning here that if you ignore the CAC's order, or if you breach the access agreement that is agreed to, that's when financial penalties can arise. So the union can complain to the CAC, and if the CAC determines that the complaint is well-founded, They can vary the agreement and order the employer then to take specified steps to comply. Under the draft legislation, the maximum penalties are looking quite substantial. So they're nominating £75,000 for a first penalty, and then up to £159,000 for a second penalty, and eye-wateringly up to £500,000 for a third or subsequent penalty relating to the same access agreement. So it's not something to take lightly. Please be aware of them, and please make sure that managers too are aware of what this could result in. As part of receiving an access request, I would suggest that you consult with other stakeholders before reaching a decision. So it might be your operations team, it might be IT if there's a request for anything digital, your DPO, data privacy officer, any security if you have a site that has security, and potentially if you have legal counsel, that might be something to consider as well. I'd also suggest to you that you develop at least one workable solution. So don't just go back with a bunch of negatives or objections. That never looks like a considered response. So try to come up with a compromise or a workable solution that you can go back to them with. And this is important. Keep a written record of any proposals, counter proposals, any reasons that you've come to, or any reasons that you've used to come to your decision, and what decisions that you've actually made. Good documentation always demonstrates that operational constraints were genuine and that the negotiation was meaningful. So document everything. You know, my old saying, if it doesn't exist in writing, it never happens. So please just be careful to do that. So a little bit of a reminder and checklist to what you need to have in place for the 30th of October deadline that's coming up. Nominate someone who will own the responsibility for accepting and dealing with access requests and recognition requests, of course, and make sure that anyone monitoring your company inbox or posts is aware of what to pass on and to whom. Put together an access request procedure and identify the physical and digital options that you might have ahead of time so that you're prepared. Again, brief your line managers so they're aware of what to do and perhaps more importantly, what not to do. Consider the impact of time off for union reps and how you might be able to cope with this operationally. And it's especially true if you've never had to deal with union activity before. Determine what documents, what onboarding processes, and as I said, what workflows in your HRIS you might need to adapt, and have an industrial action continuity plan if you think this is something that is going to impact on your business, and particularly in light of the 10-day notice period and 12-month mandate for industrial action. That is a very, very short amount of time for you to have to dream up these things from scratch. It's better to have a bit of a continuity plan, even if you don't really believe that it's likely that your business might be impacted. And of course, one successful ballot can also authorize, as I said, industrial action for up to 12 months. So it means that action could take place more than once during that period without a new ballot needing to be created each time. If you are an organisation that may need to consider industrial action and a continuity plan, there are some things to consider. Which of your services or activities are crucial and need to continue? Who would coordinate the organisation's response? What lawful staffing or operational alternatives might be available to you? how employees, customers, and other stakeholders would be kept informed. Who would do that? How would you communicate with them? And how the organisation would respond if industrial action happened repeatedly over the course of 12 months. Not nice things to consider, but better to consider them ahead of time than when it happens. The safest stance, of course, to recap the message throughout this webinar, is to be prepared for what is in place currently, what's coming down the line. Remain neutral, be responsive, so don't bury your heads in the sand and think that a union would never come into your workplace. They can and they may. And of course, unions have been planning around this for some time. And so it's likely they're going to target businesses outside of their usual focus, because they're now able to, and they can obviously get many more members in the union through this process, and they've got access to speak to people in your workplace. Anybody who's got a workplace with over 21 people, and when I say workplace, you might have 3 locations with 6 people in each. Sorry, that doesn't make over 21. My maths is shocking. Let's make it easy for me. You might have 3 workplaces with 10 people in each. That will take you over the 21 worker threshold. Now I know I'm in HR, I'm not a mathematician. I'm going to now ask you, if you will, some questions, a bit of quick revision, and let's see how many of you can get these questions right. The first one is, pretend you're a restaurant and you have a bargaining unit of 30 food and beverage attendants. 1 employee takes part in the union recognition, sorry, 10 employees take part in the union recognition ballot. How many of those employees must vote yes for the union to win the ballot? A10, B16, C6, D12. Let's have a look to see who's been listening. I won't know who you are. I'll just get a percentage, so don't worry. Okay, I'll put you out of your misery. The correct answer is C, 6. So the union needs a simple majority of the votes cast, remember. It's all about the number of votes that are being cast. The previous requirement for at least 40% of the entire bargaining unit to support recognition has now been removed. So if the union wins, it will be recognised for all 30 employees in the bargaining unit that will represent those, not just for those who voted, but only a small number need to vote. So that's one thing to remember. Second one, a union is recognised for a bargaining unit comprising all 30 food and beverage attendants. 10 of those are union members and 20 are not. Who is covered by the collective bargaining? Is it A, only the 10 union members, B, only those who voted for recognition, C, all of the people in the bargaining unit, or employees can individually choose whether to be included or not? Give you a moment or two to come up with your response. Good, it's looking good. The correct answer is C. So the bargaining unit is defined by the roles, remember, or the group it covers, and everyone falling within that definition is covered by the collective bargaining, whether or not they are a union member or whether or not they voted in the recognition ballot. Right, so that's important. And last question, you'll be pleased to know. A trade union sends your organisation a formal workplace access request. By when must you respond? Is it within 5 calendar days, by the end of the 15th working day after the request is sent, within 25 days of receiving the request, or there's no fixed deadline? Let's see how we're going with this one. Great. Looking good, folks. You've been listening. Thank you. The correct answer is B, by the end of the 15th working day after the request is sent. So the deadline, remember, runs from when the union sends a request, not from when HR happens to read it. And employers should therefore have a monitored contact route that ensures that managers pass any union request on to you immediately. Now, before we go, I just want to remind you of the next webinars that are coming up. We've got one on managing long-term sickness and how to deal with capability issues fairly and effectively. That happens in September. And I know from our client base in outsourced HR that this is a big one for many of you. And then we have some further updates on what's happening in October, and November will be focused on helping you get your house in order for 2027. When we send out the links to this webinar recording and our information sheet, we'll also include links on how to register for those if you're interested. I hope we get to see you there too. And lastly, just thank you from me. Please drop me an email at the address on the slide, sarah.gray@cintra.co.uk, and let me know if there's anything particularly you'd like to hear about in these webinars, or if you have any suggestions for what I can do to make these better for you. So I hope today has been of value. It's not a particularly exciting subject, but it's certainly one that you do need to know about. So I hope you've got something out of it today. Until next time, goodbye from me, and thank you very much for your attendance. Bye-bye.